Hi friends from around the world. Testarossa, what does it say to you? Sounds like fun. Ferrari, yes. Let's go starting with this. It is a judgment from the European Court of Justice from October 2020. Now, what is it about? You see here the trademark. Testarossa is a figurative trademark with a goods in class 12, mainly motor vehicles and spare parts thereof. There are two marks which have been registered in Germany, the one in 87 and another in Switzerland in 1990. The coverage of the goods is practically the same. Now, against these trademarks, there were a revocation request done by a third party in Germany. So there's a Swiss mark involved, but I will not go into this. There's an international treatment between Switzerland and Germany, and that is possible. Now, in the court as well, it is possible in German court to claim the revocation of the trademark. You do not need to go to the trademark office, right? So, being that out of the way, the reasoning of the claim was non-use of the mark during 5 years. So this is a European requirement. It comes from a trademark directive. I covered in video what is a directive. So it is something which has to be transposed into German law, in that case, in the law of the member states, so Germany in that case, and it was transposed into Germany. Directives already 20 years ago, so this has been done. But then there is interpretation of the directive, which is transposed into German law, but it has to be inspired by the directive. And if you want to interpret the German law, you have to take into account of the European directive, right? So what does that mean? It is possible, according to Article 267 of the Treaty of the European Union, that a national court which is seized to decide of the interpretation of European law can, and last resort in a country must seize the European Court of Justice on the interpretation of that European law. So it makes sense because you want to have one interpretation in the whole of the member states of European law. You don't want to have 27 different interpretations, then it would be a mess, right? So what do we have here? We have now in Germany the requirement to have used the trademark. In that case, if a revocation claim comes against the trademark owner, he has to prove the use of the trademark 5 years previous to the filing of the revocation request. That is the directive, and that is the German law. Now, what happens with regard to this proof of use? Now, the regional court in Germany, they thought, well, Ferrari was not able to prove the use during the relevant period of its trademark Testarossa. What did they prove was that they had some sale of Testarossa models, so the Ferrari models Testarossa, in the 1990s, so some time ago, and then it discontinued. And what they sold afterwards were either they resold some Testarossa models, so some cars, Testarossa, and what they sold were some spare parts for Testarossa, not very much. It was about 17,000 euros during the relevant period of the 5 years previous to the filing of the revocation claim. So the regional court said that is not sufficient. then Ferrari went to the higher regional court, Oberlandesgericht Düsseldorf, and the higher regional court, they had some doubts with regard to the interpretation of the European law, precisely about the directive. Now, what were the doubts which have been considering the higher regional court, and which then provoked that they seized the European Court of Justice with precisely these questions? So there were in total 6 questions. I will go into 3 of them for not being, for streamlining this a bit and not too complicated. Okay. The first question was the market segment. The consideration of the higher regional court was, automotive sector. That is is a huge sector. It's a very big one. Whereas Ferrari has addresses only one small segment of that sector, which is the sports car sector, or the luxury sports cars sports car sector, which is very, very difficult. So how would, if Ferrari is only take into account this small sector, how is it that the higher regional court has to interpret the genuine use with regard to that? Now here the European Court of Justice, they focused a bit differently. They saw that class 12 goods, motor cars or vehicles, these are higher class category, and what the higher regional court should consider is whether there is a subcategory which can be taken into account here. Now, if you go to the luxury car sector, it is very difficult to find a subcategory luxury cars with regard to vehicles, normal vehicles, because where does a luxury car start with? How would you define a luxury car with regard to a normal car? Is it the leather? Is it the equipment? Is it the price? Well, it's not very easy to make here a subcategory. Secondly, it is about the sports car. So vehicles, normal vehicles, and sports cars. Is sports cars a subcategory of normal vehicles? Again, here's the purpose. The purpose, sports cars, they may be used in races because of high performance, but it is not necessarily be used only for that, because in everyday life you can use sports cars as well. So there is no really a subcategory which can fit into. Just for that, a side remark, there's a taxonomy within the EU IPO website where you can see the whole tree of subcategories and subcategories within the classes of the NIS classification. Now, the Court of Justice, they said rather, with regard to the luxury car and the small segment and the sports car, etc., that should be taken into account in the token use and in the genuine use, where you have to determine all kind of circumstances in order to exclude the token use and only admit genuine use. And this has to be done by the higher regional court, but the indication of the European Court of Justice was, if that is a small segment with regard to sports cars, which is addressed in a way such as Ferrari did it, so would be sufficient. That was a first question. A second question was about spare parts and the goods itself. So in this case, Ferrari discontinued to produce the cars, right? But they continue to sell the spare parts for those cars. And the Court of Justice, they said, the spare parts, if they are integral part of the overall product, then the sale of the spare parts would also imply that the good itself is being maintained as genuine use, or as being considered to have been used within the genuine use requirement. So that is an important issue. With regard to the resale, there was some resale of cars from Ferrari. And there is the kind of the exhaustion argument. You know what exhaustion is. So if you sell one product onto the market, the resale, so the next selling of that product with the trademark on it, you as a trademark owner, the original trademark owner, you cannot argue against, right? So with regard to the trademark use of the resale, so of a second-hand Ferrari, Testarossa, so to say, they say, the European Court of Justice, they say, well, if it is a resale, so it is the use, the genuine use of the trademark with regard to the trademark owner, right? Not with regard to the reseller of whoever it is. So if I cannot argue against a resale, but it is still a use of my own trademark. So it is the second use, so the second sale of the mark, which continues to be a use of the trademark. So these are the questions I wanted to discuss with you, and these were the answers favorable in this case to Ferrari. What does it mean now? So there are some positives for the luxury brands, which makes it possible if they are spare parts. So if one part of what is sold is part of an integral part, then you would be able to maintain, with a sale only of parts, a broader range of goods in the same class. That is one issue where you, as a lawyer, you want to argue in that sense in favor of your client. So the other is if you have vintage goods. So you have a client producing vintage goods which are highly appreciated because you make a small amount of them only, and only for a certain period of time. And you have the resale, the kind of resale of these goods, because they are highly priced, they are highly sought for and in demand. So then you can maintain, although you have stopped the production, you can still maintain the use of the trademark with regard to these goods. And then you have these automakers which are doing some sales during a certain time, but then stop and have a different model ongoing. So these are probably those who are most benefiting from the Court of Justice judgment in that case, because they can for a long time have maintained that trademark, although it is not anymore produced. I wouldn't say that they make a resale of these cars, but the spare parts, these are long into the future, for 20 years probably maintained. So in the meantime, the trademark is being protected with what value for the company? Well, that is up to the company to choose. So that was the Ferrari case. I think it was important to see how the European Court of Justice is interpreting the kind of exhaustion, the kind of spare parts with regard to the integral part of the goods. Thank you and for tuning in and sharing your time with me.